Can a condo management bar a resident from his home if it suspects that he is infected with COVID-19? Absolutely not. On January the 28th, I was told that the Honorable YB Ismail Sabri, the Minister of Defence, had said that condominium management bodies were allowed to ask their residents to test for COVID-19, and if they declined, bar them from their own homes. I initially thought it was fake news. I dismissed it, and then I was showed a Malaysiakini report. What the minister said was, and I quote Malaysiakini, the management of condominiums and residential complexes have the right to require residents to submit to COVID-19 tests and bar those who fail to comply, Defence Minister Ismail Sabri Yaakob said today. This, if it is true, is a serious error of law. The right to a power must come from somewhere. One cannot pluck it out of thin air. There is no power in the management corporation or a condo management body to 1. Ask the residents to test for COVID-19 and 2. Bar a resident from his home because of a suspicion of COVID-19 infection. Why? Because the Act that gives only limited powers to condominium management bodies does not confer these two powers, and that Act is the Strata Management Act 2013. It is abbreviated as SMA 2013. That is a statute that governs the maintenance and management of residential strata properties, for example, apartments, condominiums, flats, townhouses, and landed strata properties in gated and guarded developments and commercial strata properties. Second, a management body cannot exercise powers it doesn't have. These management bodies can only exercise powers granted to them by the SMA. They have no power under that Act to 1. Ask the residents to test for COVID-19 or bar a resident from his home because of a suspicion that he is infected with COVID-19. The SMA does not grant them medical powers of diagnosis either, or to demand that residents be tested, or give them powers of barring a person from entering his residences. The very Act that deals with COVID-19 issues, it's called the PCIDA. It stands for the Prevention and Control of Infectious Diseases Act 1988, grants no such power to the management bodies. But what about the 2021 Emergency Ordinance? Now, neither Article 150 of the Federal Constitution, under which the current government has advised the proclamation of a state of emergency, nor the Emergency (Essential Powers) Ordinance 2021 grant any such power to condo management bodies. And here is an interesting phrase: a man's home is his castle. That maxim is one of the oldest and most deeply rooted principle in the jurisprudence of common law. William Pitt, he was the Prime Minister of Great Britain. In the year 1763, in one of his speeches said, "The poorest man may in his cottage bid defiance to all the forces of the crown. It may be frail, its roof may shake, the wind may blow through it, the storm may enter, the rain may enter, but the King of England cannot enter. All his force dares not cross the threshold of the ruined tenement." That statement was quoted in 1958 in the US case of Miller versus the United States. Now, if a resident can keep the king and the government out of his home, what more a management body of a condominium? Those who invoke non-existent laws fail to recognize that there are clear guidelines in the PCIDA. That Act sets out procedures how those who are suspected of an infectious disease ought to be treated humanely, with proper medical care, and within the constitutional rights of the patient. Now, Article 8(1) of the Federal Constitution prevents condo management bodies from taking the law into their own hands. It states, all persons are equal before the law and entitled to the equal protection of the law. Then Article 9, Clause 2 of the Constitution foresees and prevents this kind of excess. It says, subject to any law relating to public health, every citizen has the right to move freely throughout the Federation and to reside in any part thereof. The phrase subject to any law points to at least the PCDA and Article 150, both of which impose no such restrictions on a resident nor grant any such power to those management bodies. They would not be able to distinguish the left-hand side of a hockey stick from the symptoms of a Covid-19 patient. If management bodies put up any such notice as suggested by the Honourable Minister, they risk breaching not only the Constitution but also the common law as well as the criminal law. But that's a subject for another day. Any affected resident can ask the court for a declaration that such an act is illegal and that it violates his constitutional right, and he can ask for damages. There is also the provision in Section 70, subsection 7 of the SMA. Are management bodies prepared to pay such a litigant damages? If all condo residents pass a bylaw, then what happens at an AGM? Depriving a man of his access to his home and throw him out on the streets? Can they do it? The answer is no. Why? Because no body of persons can breach another resident's constitutional rights. The other residents during such an AGM can only act within the law, not outside of it. Now, what if the local council issues regulations to do all the things that the Honourable Minister YB Ismail Sabri has suggested? Again, the answer is no. Why? Because no statutory body can breach a resident's constitutional rights. Remember, Article 4 of the Federal Constitution says that the clauses of the Federal Constitution are supreme law. The statutory or administrative body can only act within the law, not outside of it. Therefore, management bodies must act reasonably, humanely and within the law, and they must comply with the strict procedures set out in the PCDA. They must act reasonably by notifying medical authorities of any suspicion they may have. You will well realize by now that our beloved, overworked, underpaid and underappreciated medical teams all across the country have set up very many proper procedures. They know better. Why not ask them? Let them do their job. And penultimately, management bodies must comply with the strict procedures set out in the PCDA. They should allow self-quarantining procedures as required by the PCDA and implement other procedures as recommended by our medical professionals. Otherwise, there will be no place in the hospitals. Management bodies should not become kiasu and play the doctor. They have no idea what that entails and they can be sued. But suppose the minister is right. Where will these residents and their children, thrown out as they are of their homes, sleep the nights? On the streets? Is the minister prepared to allow them to live at his home? Statements like these show poor judgment. They create unnecessary hysteria and clamor at a troubled time like this. I think we should rethink the entire strategy. Thank you and goodbye.